Our panel here today is going to focus significantly on some recent work that seeks to certainly bridge those islands and builds on some of the work that has been done over the years on accountability and risk-based models, but I think in a sophisticated way that tries to really build on some of the earlier work and really address both global principles and European principles of data protection law in a way that seeks to update them. And we'll debate here today whether or not these papers and processes that the gentlemen here have been involved with do so, and we'll try to critique and push back and debate it. So let me lead off with Fred Cate, who as one of the lead authors of some of these papers, together with Victor Meyer-Schomberger and with Peter Cullen and input and work from Richard, have really now sought to put this issue on the table. So Fred, would you give us a bit of an overview of the recent work and kind of the key points, and then we'll try to elucidate and debate and see if we can make some progress.
I'm delighted. Thank you. I'm delighted to be here. I'm still reeling a bit from being called pragmatic and interesting, and in an academic world that would lead to my almost certain firing. So for those of you watching on TV, she was talking about somebody else. It also had not occurred to me, Jules, until your introduction that, Jakob, I'm afraid you're surrounded by people who have actually worked in part on this project. It wasn't intended that way, but
wasn't it?
But I think
it's an ambush.
I think exactly right. But let me do say how important I think the project you were announcing earlier is, and how proud I am to be part of it. And I think the idea of working pragmatically to try to bridge gaps which have for far too long separated us, and that I think we have, with more experience, more practical ideas now to how to make those gaps be less of a barrier. I think it's an incredibly important initiative, and I offer congratulations, even while people might wonder why you allowed me to be part of it. They nevertheless, you may wonder by the end of this. So let me just say very briefly what would normally take an hour or 45 minutes to cover, which is I think we're all aware of this rapidly changing world in which data protection is taking place, and that's been very much a theme here. The advent of big data, the tremendous rise of government surveillance, the tremendous rise of surveillance technologies in general. And I don't mean surveillance necessarily in a bad sense. In other words, we all carry cell phones that locate us, that provide us maps. We increasingly are integrating technology into our lives in ways that the technology will be embedded, will be connected, will be wearable. I wear an insulin pump now, which provides a constant stream of data about me all the time, but over time that's going to get smaller and smaller, and increasingly will be implanted. It won't even be a separate device, and of course, it's also been discussed here, the Internet of Things, where we're going to be surrounded by devices, by lights, by cameras, by refrigerators and toasters and other appliances that are constantly yielding a set of data that will be linked to individuals. And so I think the challenge that we face across the world, by no means limited to Europe or the United States, is how to keep data protection current in the face of those challenges. How to, exactly the challenge that Commissioner Graham was talking about, how to make sure that without changing any of the fundamental goals here, we make sure that we're using tools that work in this, whether you think it's a brave new world or a horrible new world, it seems to be the world in which we are emerging into. So to address that challenge, 18 months ago, just outside of London, a group of us got together, three former commissioners, including Richard, and an economist, and Victor and I as academics, and Peter, who was there as the token Canadian. So it sounds a little bit like a bad joke. 5 lawyers, an economist, and a Canadian walk into a bar, and this is what happens. But our goal was trying to think in terms of meeting these new challenges. What are the fundamental changes or evolution of our current system that would be necessary to ensure that the rights that we consider fundamental are in fact protected in this phase. So let me just make 4 quick points here. The first, and that is that the data protection systems around the world need to place more responsibility for data stewardship and liability when the stewardship fails. So both stewardship and liability on the users, on the processors of data, and place less responsibility on the individual in terms of notice and choice. Right? We all live through a sea of notices. Virtually nobody ever reads them. They're incomprehensible when you do. Notices may serve many important purposes, but there may be better ways to accomplish those purposes. And in fact, of greatest concern to all of us in that group was the fear that choice was being used too frequently on both sides of the Atlantic, but frankly, maybe no place clearer is this than Canada and the United States. Choice was being used as a way of shifting responsibility onto individuals, to say, you consented, and therefore, now we can do something with your data, which might not actually be in your best interest. So the second point is that as we engage in this increasing focus on data stewardship and data and liability for uses of data outside of appropriate stewardship, that we should focus more and more attention on uses of big data, as opposed to focusing exclusively or significantly, as is the case, for example, in the United States, on collection and retention of data. And the reasons for this, I think, are obvious, but especially in a world of big data, in which data have enormous value for all sorts of uses that will have utility that in some cases can be, in fact, life-saving. If we still go back to what was the moment in time in which the data were collected and what was the terms of consent at that moment or what was the stated purpose, we are inevitably going to be restricting valuable, potentially critical uses of data. Moreover, I think one of the things that really struck us in this process is that uses of data are where individuals tend to be most affected. And I don't at all mean to suggest that individuals are not affected by collection or access of data. By the way, access would be considered a use. But rather to say that there so often is an obvious reason for collecting the data. Look at Edward Snowden's revelations, for example. The data were all lawfully collected. The phone companies collected them, others collected them. The question was the subsequent use made of the data. It's in that context that we suddenly see a significant, threatening privacy violation when they are repurposed in a dramatic way that is focused so much more on the power of the government and on the terms of collection rather than on an assessment of risk around use. And that assessment for risk seems incredibly important as a way to allocate scarce resources, as a way to focus attention, but not as a replacement for other types of protection, rather as a focusing mechanism, as many of our participants referred to it. The third principle is that as we increasingly focus on risk, which we're already doing, we have risk assessment requirements throughout Europe, we have them in the United States, we have them in much of Asia, for privacy impact assessment or for other types of assessment, we need to start thinking more collectively about what are the types of risks we're worried about. Up until this point, it's largely been satisfactory to say, well, we worry about risks such as non-compliance with the law. Well, that is a real risk, and we should worry about that. But increasingly, because of the role that that information plays in individuals' lives, we better be worried about the practical harms, the tangible harms, the harms that can result in significant economic disparity, that can result in people being disadvantaged in extremely clear and direct ways. And we really need to focus on a way of developing a common vocabulary for risk assessment. What is it we think when we're doing privacy impact assessments? What are those impacts we're worried about? What are categories of impacts? What are tools? What are methodologies? And this is an area in which Richard has been quite influential and spoke, I think, yesterday here about. And then finally, I know those are the words you're looking for, we need to ensure that as we continue to evolve data protection to respond to these significant challenges, that we always are enhancing transparency and redress and enforcement. And transparency, especially if we focus less on long notices that nobody reads, which I would argue don't really provide very effective transparency, we need to be thinking of better tools for providing transparency. How do we achieve the type of openness that builds the confidence that we care about, that people have, that their privacy will be protected? How do we ensure that there's redress for individuals who are harmed or injured or affected in some way by the use of their data? And how do we ensure effective, well-financed, well-targeted enforcement? And without those tools, no system's going to be effective in the future. So Let me say, I don't think we proposed January, now 18 months ago, an answer to all of these problems. We proposed a beginning of a process to try to look at them, a way to not in any way alter our understanding of fundamental rights, but rather to ensure that those rights continue to be protected as we move into the brave new future.